My lord, one appellate side mentioning, my lord. I was mentioning one matter of the appellate side, my lord. But I have filed the application. Let it just come up in the list, my lord.
Yeah, give the application.
Great.
Well, this matter, my lord,
Is now assigned.
yes, my lord, it's been assigned, and my lord was pleased to, my lord,
It was difficult earlier.
my lord, this has come up, my lord, for extension of, my lord, the interim order, which my lord was pleased to, my lord.
No, earlier the assignment was only for a day.
Only for a day?
Yes.
Huh?
Where is the earlier assignment?
No, my lord, this is, my lord, assigned to my lord.
आगे का assignment order कोता है? File टा कोता है?
Day, 27, 20, 30. Huh?
ఈ matter টা extension এর জন্য one day it came. No.
No, my lord, it's assigned to my lords. Unfortunately, my lord, it was fixed, my lord, on the 20th, but my lord, because of, my lord, the full court, my lord, reference, my lord, it couldn't be taken up. My lord, I was praying, and my lord, the first, my lord, it was taken up on, my lord, 27th of February, correct. My lord, I have the orders, my lord. Achha, order sheet, achha.
It's not that. It's not that. No, I don't think it was for one day. Send it back and Yes, who is for the other side?
Lord,
what is this matter?
Lord,
It means
and my lord, order passed, my lord, in execution, which, my lord, my lord, our contention was, my lord, the decree award, my lord, was fully satisfied by entering into a family arrangement. There was also another execution application filed, and an order was passed. In spite of that, my lord, again, another execution application, my lord, after, my lord, 7 or 8 years, and further orders have been passed, my lord, which will not be resisting, saying, my lord, that can't be done. Questions of, my lord, res judicata, as well as, my lord, question of, my lord, the award already being satisfied, my lord, so far as
extension till the end of the matter has come up by way of an assignment before us. Stop. It appears that the interim order / assurance was given by the respondent. Sorry, it appears that the interim order was passed by this court. It was an interim order or assurance?
Well, there was an assurance saying that there will not, or
it appears that there was an assurance given by the respondent, and on the basis thereof, the court passed an interim order that the existing state of affairs would not be altered at the instance of the respondent till the court is in a position to consider the said application. Let this matter be listed.
Lord, if next week, my lord, if
27th?
Yes, no difficulty. No difficulty.
27th?
First week of April. Very good. I'm not there.
28th?
We have no difficulty.
Those 2 days.
We have no difficulty, my lord. I leave it entirely.
I'm not there. Those 2.
Why? Why not there? The court is open. The work is on.
And if it is possible, otherwise.
No, where is the difficulty? Why?
Section 47 will dismissal appeal.
Whatever. So that's why you should be more eager. You should be more eager.
We have agreed to an interim order also.
Whatever, but you should be more eager to get it done. So come on 27th. Curtail it. Curtail.
Then first week.
Curtail the holiday.
I have a senior, but not kindly, if it's possible. Otherwise, we'll make it.
2nd April.
So then can it be first, my lord, first or third?
First.
27, 20th, I have no difficulty, my lord, first or third, my lord. Second, there's another matter fixed at 2 o'clock, my lord, that's the only difficulty. That we are.
We'll take up it in the morning.
Morning.
We'll take up in the morning.
Very
From 2 p.m. that is the problem. One in the morning,
Lord,
no problem.
My lord, second, my lord, I have some difficulty. I'm here, but my lord, there are two matters fixed, my lord. First, my lord, if it's possible, my lord, or third.
First month.
Huh? Monthly election.
Then come on 4th.
Okay. SVP আলা আছে, আমি জানি না, তাহলে তুই have to-
Who are the same?
ঠিক আছে। বেশ,
At 2. 4th.
একটু।
Yes.
And my lord, the interim order, my lord, is still, my lord,
Yes. Oh, I said till the April. No. Sorry. তার আগে লাগবে। Let the interim order recording the assurance passed earlier be extended till the end of the month of April 2024,
Grateful.
or until further order, whichever is earlier.
grateful. কথাটা যে আমি থাকবো, কিন্তু কিছু করার নেই তো।
তোমার ঠিক circumstances এ তুমি আছো, কারোর জীবনে থাকতে না।
No, no, of course. 27, 20th, I am there. So I don't know what to do. I'm looking for matters.
I have told Mr. Banerjee that because of these circumstances, he's here.
No,
Otherwise, he's the last person to be here.
no, ওখানে ছুটি, পুরো সপ্তাহ ছুটি হবে।
No, I know the urgent determination where he will destination where he will land.
No, my lord, that is not a whole week, my lord, holiday, my lord.
চলে যাবে।
যাচ্ছি। Grateful. যাচ্ছি।
Who is appearing in item number 1? এই এখানে কোনো রেসপন্ডেন্টের নাম পাচ্ছি না, দেখি দাও, দেখি ফাইলটা দাও।
There's nothing, there's no slip for response. I got it checked twice.
Where is Mr. Shaunak Bhattacharya? So, Abhirup Halda. Just call him. Anybody can give you an information. Mr. Shaunak Bhattacharya.
In view of the foregoing consideration, we find no reason to interfere with the judgment and decree passed in mat suit number so and so. The appeal is dismissed.
সরি, ওদের রেসপন্ডেন্টের নামটা একটু জেনে নাও বাবু, দেখে নাও।
But I have for the response.
And I'm for the appellant, my lord.
The impugned judgment is set aside, the application for dissolution of marriage is dismissed,
Wait.
and the application for restitution of conjugal right is allowed.
My lord, I paid for a deed to file appeal in the apex court.
What?
File appeal, my lord, in
What
the-
appeal?
In this order, my lord, by the apex court. My
No,
time
no.
was-
What appeal we don't, but we can't grant you a leave to special petition under the constitutional provision.
I'm not special.
Then we'll have to satisfy that whether it involves the question of law of the general importance.
Only want to he wants want to file the appeal. So
No, that you should know that what prayer has to be made.
my lord.
After the judgment is delivered, the counsel for the respondent prays for a stay of the operation of this order. Stop. We do not find that there is any case made out for such requests. Accordingly, the prayer for stay of the operation of the order is rejected.
My lord, Mr. Bhattacharya was called, my lord. He did not pick up, my lord. I'll inform him, my lord.
The campaign in election, he was the candidate.
No, no, I'm
What?
bound.
So
Mr. Bhattacharya, Mr. Shaunak Bhattacharya, my lord.
He's a candidate.
No, no,
Bhattacharya,
sir,
Bhattacharya.
bhulwal.
So was the candidate?
I'm talking about Mr. Bhattacharya, my lord. Shaunak.
I'm appealing for the appellant, my lord. I'm for the respondent.
He has said that since the respondents have entered appearance in the instant appeal and the stand so taken is indicative of the fact that they wanted to contest the said proceeding, it would be proper that the matter is reverted to the probate court to decide the same in presence of other respondents. Furthermore, the respondents have entered appearance in the instant appeal and therefore have a knowledge that the application for probate to the will annexed thereto is filed. There is no necessity of further citation to be made in this regard, and it would be deemed that the citations have been made upon the respondents. The respondents are at liberty to lodge a caveat within 15 days from the date of this judgment, and if they chose, may file an affidavit in support of the caveat within a month from date. The trial court shall proceed with the probate application de novo, permitting the parties, including the propounder, to lead an evidence, and it is expected that the probate court would arrive at the logical conclusion within 4 months from the date of the communication of this order.
Can I go also? Well, lord, thank you.
Sure, let us sign, sir. What? You have a substantial practice here. You should know unless the order is signed,
After that,
how can it be given?
after sign.
Yes. দিয়ে দাও পড়ার জন্য চাইছে দিয়ে দাও We do not find any involvement of the substantial question of law. Appeal is accordingly dismissed. Yes.
I beg to appear, my lord. My lord, my lord, this has been assigned to my lord, my lord. On last week, my lord extended the interim order up to this day, my lord. Up to this,
Because there was a difficulty.
yes, on the
Assignment was only for
on the
today.
day.
Today, I
The
said
word was
check
permitted to move today.
today. That is
That's
that
the
is-
whole
yes,
problem.
yes.
Now it has assigned.
Aside.
So
I am opposing the fair for extension. What is happening in this matter? You'll also
Not
kindly see this photograph. How he is registered. It is inhabitable condition of this house. He has been granted to the scheme grant of the Pradhan Mantri Awas Yojana. That grant will be returned. By virtue of the interim order, he is resisting constructing.
sir, there was an interim order granted.
He
Now that was extended. The moment the court finds that that is a fit case for interim order, unless we decide the entire matter, we should be appreciated.
file an application for vacating.
Now,
And this
now the question is, when both of you are ready, we can dispose of the appeal.
I am ready always, my lord. You also today, my lord, itself I am ready, my lord.
I am ready, my lord. With
So
subject to
today,
yes, I am today even ready, my lord. Since they have filed a vacating application. What I propose, my lord. If-
vacating will be treated as an opposition. We will not go.
yes.
We will
my lord.
not go by that.
I have
My lord, there is
my lord.
application for section 5, my lord, that was not in condone, my lord. It is not.
What are you saying? Section 5 has not been
Not-
condoned.
No, my lord, that has been recorded in the first order. That has been recorded.
Without Section
My
5
lord, for the some urgency, my lord, that has been recorded.
granted.
The urgency, my lord, with regard to resist me, my lord.
Granted.
No, no, it has not been granted. But for the emergency situation peculiar that has been
Can
recorded.
an interim order be passed without condoning the
My
delay?
lord, that is my lord.
Yes, that is my lord miss. Look at the provision of
My lord,
Order
I know, my
41,
lord.
Rule 3, capital
Kindly, my lord.
A, capital A, sub
Yes, my
rule
lord, I
3,
know, my lord.
sub rule
Since
3.
my lord, on that day, my lord, they say, my lord, they will file an objection to my section 5. My lord, that is why, my lord, court said, my lord, kindly,
Come on Thursday and argue the matter.
my lord, Thursday, my lord, I am not. Next week, my lord, I am not in town, my lord. Kindly, Tuesday, my lord. My lord, every
5% handicap person.
Sir,
handicapped or
emotions, sentiments,
yes.
sympathy has no role in so far as the law is concerned.
That 2.5.
If the law prohibits, it prohibits to all. You cannot say.
What I want
So,
to say, my
so
lord,
we do not know. Let us see when we can fix. Both
Lord,
of you,
Tuesday,
we
Lord.
are ready on a very next available day because today is a date. I am ready.
থাকবো না। আমি থাকবো না।
What is-
মঙ্গলবার মঙ্গলবার
Again, I am saying what has happened, what has not happened, I am not going to hear. Tell me,
on
both of you, tell me the date.
second
on
of
that
April,
first
my lord.
available
Second
date,
of
we will take
April,
up.
my lord. Second of April.
Why not first?
First Monday, my lord.
What is the difficulty on Monday?
My lord, kindly have.
It is still a fresh, no difficulty.
The government will be returned, my lord. That is my problem.
No document has been submitted
No,
to
when
that
there is
extent, my lord. I am not-
Don't try that the court should make an observation for that.
No document has
There
been
can
filed.
also be an observation against your client.
Only from the bar, my lord, they are saying. My lord, kindly accommodate, my lord, on 2nd of April.
First, 27, 28, you have problems. First available
Lord,
date is
perhaps,
first.
my lord, if I late return, my lord, that is why, my
That
lord,
late return will not do. You'll have to return by Sunday.
By driving.
5 minutes, my lord, clear the fact, my lord, how they resist, my lord.
My lord, on suppression of material fact, the writ petition has been filed and obtain an order without, my lord, directing the police to get help to, my lord, construct her a house. On a pleadings that 2 suits filed by us was dismissed. Whereas, civil revisional application challenging the order of the first appellate court, my lord, is pending before the High Court, and in spite of receipt of that order, my lord, copy I will produce from the records, my lord, suppressing that the husband, what prompted by the wife, the writ petition has been filed without annexing any document, whether the
Is it unusual?
it is not unusual. That is why, my lord, I've said, my lord. So there is many things to say, my lord. Submit, my
Come
lord,
on first.
as you lord.
The matter has been assigned to this bench by the Honorable Chief Justice. Stop. It appears that the interim order was granted earlier, which is continuing. The respondent vehemently opposes the prayer for extension of the interim order. Stop. However, we feel that the justice should be served if the appeal itself is decided finally. Accordingly, let this appeal be listed on 1st April to be taken up as first matter. Stop. The interim order granted earlier shall continue till 4th April or until further order, whichever is earlier. Grateful. Grateful. That's Virothi. I do not know whether 5 has been called. We have delivered a judgment.
Name has not been recorded, Mr.
Because it will not be recorded. The slip does not reflect the name. Memo of appearance which was given does not reflect the name. Then what can be done? Then why you gave without his name?
I was not.
Why you gave?
I was presenting here at Mr.
Sorry. Then why memo of appearance was not given? Your name was not there. What can be done?
That was an online one.
Sorry, we can't. You have to give whatever memo of appearance you give, we recorded. Very easy. The moment the matter, rush. Give. What is give the names? And for whom? Yes, call the names.
For the applicant husband, my lord. Applicant husband, my lord. This is the restoration application.
Have you served the copy, sir?
My lord.
Where is the affidavit of service?
Kindly have a look, page 15.
Just let me have a look of service
My lord.
first. What is the name of this? JB. What does it mean? Oh, Jolly. It was dismissed for default. When it was dismissed for default?
So kindly have a look, page 15. Non-appearance along with the failure of depositing cost.
Whether there was any interim order? There was no interim order.
My lord, because it is a transfer brief. That I cannot say.
Transferred brief. How?
So far as my instruction is, there is no interim order. There is no order of maintenance or not, I don't know.
Why FAT 3 of 2008 order is annexed at page 14? What is this? This is FA 256.
Page 14.
Huh? What is this FAT 3 of? So what is FAT 3? No, it was FAT 3, 2008 appeal. And then FA number has been given. Once already this restored. problem. It was dismissed, the application. Can. So what are you doing? Every time your can application dismissed for default, not restored. Appeal dismissed for default, not restored. There was a defect which was pointed out. No attempt has been made.
Minus.
Why? 25(8). Is a matrimonial appeal or what?
Yes, minus.
Then what a 2008 decree? What do you expect now? After so many years?
Whatever my instruction is, there is a chance of reconciliation. That is why.
Go and live together.
But there is only chance. I know.
25(8), non-compliance of 5(8). TBX time was granted for submission of the reports. It is dismissal. Not a dismissal. Because he is not put in the requisites. There was an order. Go and file the requisites first.
My
then
lord.
we'll consider.
My lord. Great.
Next. You are the advocate and record the applications. You should move. Move the applications. Oh, that's good. That you should move. 260. Let's give the file. This is the restoration. Have you served the copy? Give us the affidavit of service. Give. Correct. Addressing cannot be done. Received and all everything. Not be located. Addressing was located. It is a not good. It is a good service. But addressing could not be located. Address. Not the address is not correct. Do something. Hurry. Sir, the postal article has returned with the remark addressee could not be located. That means he is not there at the address. Are you aware of any other address? This second appeal arises from where? Any execution proceeding is continuing. So can you serve the learned advocate who is representing him in the executing court? No, not informed. Have you served him a copy also, advocate? Why don't you serve his advocate? His address may not be there. Execution has to be. The defendant is hereby directed to do the supervision of the execution order. Has to be. Since the appellant files the affidavit of service, which is taken on record, it appears that the service could not be effected as the postal peon was unable to locate the respondent at the said address. The record reveals that an execution proceeding is pending in relation to a decree which is the subject matter of challenge in the instrument. To obviate any complication, to obviate any complication, we therefore direct the learned advocate for the appellant to serve a copy of the restoration application upon the learned advocate representing the respondent in the executing court by hand, and shall file the affidavit of service on the returnable date. List the matter on
उनको दिक्कत नहीं है ना, पक्का अभी 3 मीटर बाद हो जाएगा.
on 8.
Two 61.
Yes.
261, your lordship, I'm praying for not
What
today.
is this application, sir? This is a very old application
The
of
stay
2018. Let us see. Oh, we wanted to furnish you the certified copy of the commissioner's report. And where is the certified copy of the decree? It is against the point. Sir, where is the certified copy of the commissioners? Then this is not improper. We are dismissing your appeal.
Kindly, Mr.
Where is the certified copy of the commissioner's report? It appears that on 1/12/2019, I was a party to it and I directed that copy of the, sorry, not on that. Yes, 20th of November 2019, we directed
The
you
commissioner,
to furnish the certified copy of the commissioner's report. Sir, it is against a final decree.
commissioner's
You are
report,
supposed to file. This forms part of the final decree. You will not file it. Keeping in your file.
The commissioner's report is here, Your Lordship.
It has to be. This is against a final decree. Accepting the commissioner's report. Just imagine. And where is the ultimate decree which is passed?
Final decree.
Where is the ultimate decree? Give that commissioner's report. Consider. Here the document sheets for instructed plaintiffs adopted by shown in the local text. It's adopted is if you this is effect. And adopted to defendants is great. Actually, joint. Single joint. So this is E. CD A, C, D. This is the adopted one. This is this is her entrance. इसका entrance यहाँ से होगा जो भी this will be इसमें बोलूँगा इसके बाद absolutely unadmitted, but undisputed, it is admitted. वहाँ से फिर पकड़ी जो था नॉर्थ को पकड़ this is what is fixed point, but fixed point are in the exact position has to be वहाँ से फिर खींचा इसने स्केच बना so area of block quantity with block square feet First floor. Entitlement of share. Share कितना? Total. इस share का क्या है? Scientific name. Yes, let the certified copy of the commissioner's report filed today be taken on record. The let the said report be tagged with the memorandum of appeal. What is this application for what?
Application for stay.
2017 judgment and decree passed, and now you are asking for a stay in 2024. Serve the copy and come back. Service returnable after 3 weeks. Next.
I am for the respondent number 1, opposite party number 1.
Where is Mr. Somnath Gangopadhyay? Is appearing for
Yeah, man, probate of the will has been granted in my favor in 2018. This is an application filed by the appellant, my lord, praying for stay of operation of the judgment and decree in
is
2019.
appearing since long.
Yes,
They
application.
are not appearing. Let us see
My lord,
the
the matter has not been, my lord, the issue is, my lord, the application is for stay of operation of the impugned judgment.
Sir,
Yes.
we understand.
Yes.
We understand. I am asking whether this matter is
Never.
appearing in the list for a pretty long time.
Yes, very much long
Was
time.
it
We are
taken up
suffering.
earlier?
No, my lord. The matter has only been taken up in 2023. Two orders are there, my lord. The original order of 15th of January 2019, where the stay application was considered as an injunction application, and the court granted an interim order of interim order in respect of the nature.
That has expired.
That has expired long back.
They
Nothing
are not.
no initiative has been taken for hearing of the application. No prayer for extension of interim order. It has already lapsed. I believe, my lord, they are not willing to proceed with this interim application.
Then dismiss for default.
Well, that would be the appeal may be, the paper books are there, my lord. Already I said
No.
it has arrived.
The application would be dismissed for default.
My lord, the two affidavits in oppositions, my lord, of 2019 are lined.
Sorry. We are dismissing it. Application. Next.
Please, your lordship. I'm appearing on
That
behalf of the.
old application, what is this? 2018?
There is two applications pending. One is for leave to appeal and one is for stay of operation of the.
Leave to appeal has not been granted, and the
Not yet,
appeal is of 2018. What are you doing? What are you doing?
Your lordship. The impugned order was passed in the year 2017.
Not order, the judgment.
Judgment.
What is the judgment?
And I am the appellant is the one of the beneficiary of the will. The executor is not inclined to file the appeal. That's why I beg to appear and filed an application for leave to appeal. I intend to consider.
No, executor. Who is an executor?
Executor is the cousin brother of the appellant.
Who is? He has been made a respondent or
yes.
pro forma?
Yeah.
Which one?
Respondent number 8.
The application for probate is rejected. Dismiss.
Dismiss.
Objection allowed.
Objection allowed.
You are a beneficiary only.
I am the beneficiary.
Or sole beneficiary, or
I was the beneficiary along with the executor. Executor is one of the.
There was also a beneficiary.
One of the beneficiary.
And you are the other beneficiary.
Other beneficiary.
And who are they? Who are they? The objectors?
Objectors are related to the will testator.
Sorry?
Legal,
How?
legal heirs, cousin brothers, sons.
Was he a bachelor? The
No, no, no,
testator,
no, no, no. She was married.
testatrix.
Testatrix. She was married lady. She was having
Having-
sons, daughter.
She has deprived sons and daughters.
Some deprived, some were allowed. Husband also filed. Husband was also given one will. That is another matter. This is the matter about a will of Mohini Bala Naskar, deprived some of the sons and given to the
Who are
grand.
they?
I am
Are they
appellant.
sons? This
Appellant is the
Aurobindo Noskar, Sukumar are the sons
sons
of
of sons.
testatrix.
Testatrix.
They are the sons.
I am the grandson of the Mohini Bala Naskar,
Whose son? Sukumar.
Sukumar.
Sukumar is the respondent number 2, who is also objector.
Yes. And Aurobindo's son is Kaushik Naskar, who is the
How is
respondent
your
number.
relation with your father, Sukumar? Why Sukumar is coming and objecting?
They were objecting some.
Must have an apprehension.
Must have. You can always put it as.
Section 3(1). Apply case of an intestation.
Said that she then he said that she died in
Because what the same server is from. He actually reported so failed to apply. But he has chosen not to come. He technically the position. Still there. Refusing to take steps. He is a continuation. What I'm just thinking aloud, that's why I because it's someone to get continued. Saying that the government is not really taking any steps. Yeah. If the government is not taking steps, then the merger and the break some administration. Because the bill came out, that's why I said 252. Not in favor. Effectively intent. The letters of administration would be interpreted to administration in case of intestacy. Intestacy is the for the purpose of perfect. Yeah. Administration. If he receives remorsals, then the probate can for the probate committee instructed to the executive. It is not a decision. It is the administration which decision. Do subset. He does not then apply for such a review. That is of administration. You can do it. We're just thinking in that. There's where the it's not announced the execution because he has not announced. Letter will not be granted to any other person until the citation has been issued, calling upon the executor to accept the remarks of the execution. Yeah, that is what I was thinking. Whether we could activate it now, maybe are you ready to transpose yourself as evident or you transpose? Leave. Maybe shows that you have a right to appeal. You are one of the
One of the-
beneficiaries are difficult.
I-
The difficulty is 222, 229 and 231 of the Indian Succession Act. So read the provisions.
Then I will. You'll actually one correction, only respondent number 4 to 7 raised objections, not the fathers of that. They raised only objections.
Then why you have implemented a father as a
Because they were the party in the original suit, that's why we have.
unnecessarily
That was,
tell us that how can you
there is no other options to raise.
no, there are options, but there are certain things which I believe has to be done.
I have to take
That has not been done.
being a beneficiary of that will.
That is what is the problem, because if you look at section 231, it talks about
Right.
the administration to such a person who would get it in case of intestacy. Intestacy you will not get.
No,
Your father is alive.
my father is not alive.
He's dead now.
My father.
Your father is alive.
Yes, he is alive.
Your father is alive. So if he is alive, then he is a class 1A and you are not.
But I'm the beneficiary.
Sorry?
I'm the beneficiary. I'm having the right. If I would have
Hey,
succeeded.
Without knowing he is arguing. Do you have the copy? Read the.
I'm not having.
Read 222 first. 222 first. It can only be granted to the executor. Either named or by necessary implication one can. Then read 231, right hand side page. If the executor renounces, suppose if he says that I am not going to, then who can apply for letters of administration? Any person who can administer in case of intestacy. Now, question is that he applied, but he is not ready to file an appeal. That means he renounces to act as an executor. If he renounces, then in case of a intestacy, you are not coming.
No.
That troubles me. That is why I asked this question to you. But still, I'm saying the right to appeal should be there with you, but you'll have to satisfy. For very simple reason that if this dismissal order goes, then at least the court has to grant probate. But the difficulty is that this executor has decided not to. He renounces. Then what will happen? 2, 5, 4. Intestate or living. There is no executor willing and competent executor is some person to administer this to other than the person who in ordinary circumstances will be entitled to court may in his discretion will be active consanguinity about the interest and the safety that the lawyers got. So these are the restrictions. The orders it is. It's like this. But removal is there because if he does not act, then somebody can ask for the removal. He can ask for the removal. So, specific provision.
Okay, 301.
Have you served the copy on the executor? Executor,
Execute.
have you served?
I have served the,
Served the executor also, who
Yes.
is made pro forma
yes.
respondent. That's why I'm asking.
Yes. He is the
Where?
8. Page 5, Kaushik Nastar, last the postal receipt is nice. And he has delivered page 13. Delivery confirmed.
Oh, in your matter, we have delivered a judgment. Do you know who was the other side? Who appeared?
Notice of appeal was served. One Mr. B.K. Samanto appeared. Thereafter, no representation. The division bench, presided over by Justice Somention, directed administrative notices were to be served by both ways from this honorable court and also through the legal aid of Malda district. Even if it was served, no one appeared.
No one appeared.
No one appeared. But the Vokalatnama of Mr. Borun Kumar Samanto is on record. At initial stage, he appeared.
But somebody appeared for the respondent.
Yes, Mr. Borun Kumar Samanto, his Vokalatnama is already on record.
On that day, he
Not
argued.
at all, not at all, because he has given.
But his arguments were advanced.
Not at all.
Yes.
My lord will kindly check the video recording. I only appeared. This is, I think, that the Christian Indian Christian marriage act.
Yes, that is the.
Nobody appeared. It was ex parte because to record the
Yes.
the mail. My lord, they have on the last occasion. My lord, one copy of the email was, my lord, they are on the record. Mr. Samanto appeared and said that his client will not contest the case. Unofficially, she has been married to
Yes,
Canada.
yes, that email was handed over. That we have noted in the. But
Well,
somebody appeared to
That
hand
is
over
what
that.
Mr. Samanto.
That is Mr. B.K. Samanto.
BK Samanto.
BK Samanto.
Just record.
Notice, administrative notice was
Oh, understand. BK Samanto.
B.K. Samanto. But no, on the date
He
of
said that he has nothing to do. Whatever you pass an order, his client is. Yes, that we have recorded.
that
Hey, BK Samanto.
B.K. Arun Kumar Samanto. Arun Kumar Samanto.
Yes, B for Bombay. BK Samanto. You just come ready.
Yes.
You come ready and tell us on the next day.
Grateful.
Right, okay. Like, you to regular appeal 96 होता है. The person agreed. I can find it. 300.
My lord, I take leave to appear for appellant in the matter, lordship. 264.
Oh, yes, matter 299. It's an applicable location. Every order. That is an So it's 96.
My lord, I seek leave to appear for appellant in this matter.
Yes,
My lord, I seek leave to appear for appellant in this matter, lordship. This is a matrimonial appeal against the
see, your matter was after 3 matters.
lordship.
Yes, your matter, this matter was listed after 3 matters.
Lordship.
Yes. That we heard that your matter is after 3 matters.
No, lordship, this is item 264.
Yes. And you said when item 261 was there called,
No, I didn't say anything, lordship.
you said that your matter will be is after 3 matters. Don't worry, I'm ready.
Oh, I'm so sorry. I didn't know Mick was perhaps accidentally.
Yes.
I'm so sorry.
What is the application?
Lordship, there was a decree for restitution of conjugal rights. Although the factum of marriage is denied by the wife has filed this appeal, Lordship, with the application for stay, prayer for stay. Although the decree is passed in 2018, the opposite party has not initiated any execution.
Madam, the decree for restitution of conjugal right is not a executable order. So what is stay?
Lordship, as it pleases. Then may I serve and come back after 2 weeks?
You secure their presence so that you can expedite the hearing of.
Lordship. So
Sir.
I'll serve. This is the first time.
After 2 weeks.
Grateful, Lordship.
I 65, my lord, in this matter, my lord, I am appearing for the appellant.
60?
65, 265, my lord. My lord,
Some matter, earlier matter on your ground sometime was.
There the question is whether the civil judge senior division has the jurisdiction to entertain an
Have
appeal.
they filed any opposition?
No, there is no direction for subject to question.
The order says
No. Yes.
Mr. Kushal Chatterjee
Yes.
appeared. Opposition has been filed.
No, my lord, today is out of station. I know, my lord.
Tapan Kumar Mitro, he was appearing. There was a direction for opposition.
There's no opposition is filed. But I know, my lord, Mr. Chatterjee is out of station.
Where is a copy of the decree?
No, this is the decree.
You have not filed the decree.
No, the DD was not been drawn up because, my lord, it is an application.
proceedings under section 18 and 20 of the Hindu Monetary Guardianship Act was filed before the London Civil Judge Senior Division. The question cropped up whether the court has a jurisdiction to entertain such application. The learned court will is of the opinion the Civil Judge Senior Division
Section 9 of the Hindu adoption
18 and 20 in the
of the Hindu adoption
Internal
and
Maintenance Act.
for giving adoption to a child.
No, for the protection of the property.
Okay.
The civil court is of the opinion that the court, as mentioned in section 18, is the court of civil judge, London district judge. It cannot be the civil judge senior division. Well, I need some time to prepare also myself in this regard.
No, these are the very rare cases that comes. That's why I'm just asking. This is under the Minority and Guardianship Act or adoption. What?
Adoption, in the Adoption and Maintenance Act.
Minority and the Guardianship Act, I was just thinking aloud, but adoption and
Section 8, every service.
that is the maintenance of the wife.
Wife. 18 and 21.
A child.
Yes.
I thought '19 is the maintenance of the widowed daughter-in-law.
Section 18 of the in the Adoption and Maintenance Act, section 18 and 20. 18 is of the protection subject to condition, the D is the protection of the
And this is the maintenance of the children.
Also.
Where is the provision relating to an approach to the court?
Yes, my lord, the court as defined, my lord. If you lordship may consider section 23.
It does not talk about the court is a district court or a court of.
Yes, my lord, now the kindly consider the section 9, subsection 2. Aye, my lord. Sorry, my lord. Court means city civil court or a district court within the local limit.
Where? 9?
Explanation, my lord. 2, aye. Aye, 9,
Oh,
aye.
this is okay. Court means the city civil court.
It's not
No,
principal
it is for
civil
the
court.
purpose of adoption.
Yes, now the court held, my lord, this court means, my lord, that includes the.
No. The explanation says that it is only for the purpose of this section. It does
Yes.
not talk about the other provisions.
Our argument was that the section 9 does not exclude section 9. So the other provisions are concerned, section 18 and 20.
The explanation, no, it says explanation for the purpose of this section.
This
Means section 9. The court would mean the city court or the district court.
and apart from this provision, there is no other provision in the act.
We'll have to go by the code of civil procedure.
Then section 9 will apply.
Section 9.
We have filed the suit before the London Civil Judge Senior Division.
The court of the
Bengal Civil Court, one of the lower judiciary according to valuation. According to lower judiciary, according to valuation.
lower judiciary.
According to valuation, we have filed before the London Civil Judge Senior Division. The court is of the opinion, in view of this provision, it should be filed before the London District Judge. Challenging that one, I am before your lordship.
What you want?
So there is no application, well, nothing.
Nothing is there. Application, why?
It is only for securing presence on the other side, my lord. Otherwise, my lord, it was declared that the court has no jurisdiction, I'll have to take steps before the landed district judge. And if my lord,
Can you bring Kushal Chatterjee?
yes,
It's
he
a
is out
pure
of
question
station.
of law. We can decide.
Yes,
it
yes,
on
my
the-
lord. He is out of station, my lord. Keeps us any next
Not today. Let
no,
us see.
next week, my lord. After 30th.
Next week,
No,
the
but
application
then-
may not be taken up.
then it's okay.
Yes.
Now, this is an application for restoration.
Which one? 267. Have you served the copy?
No, my lord. So this is ex parte application. In order for to earn, this is for
But a right has accrued. Maybe an ex parte,
that's
or
true.
but right has accrued. So they should
Your
get a
lordship should desire
serve short notice.
short
2 weeks.
2 weeks. Good.
Yes.
This is my lord. I am for the appellant petition. Application under section 5 of the Limitation Act for delay of 14 days and also for an order of stay. Because this
You are appearing.
you
You are there. 15 days. 15 days.
that is can number 2551 of 2020.
There's application for stay also.
What are you talking? 213 days.
Yes, my lord. So it was filed after the COVID period, my lord. That's why,
Some time has been
6th
excluded.
March 2020, my lord.
But our office report says
At that point of
230.
time, my lord, the judgment was not that judgment of the honorable appellate court regarding the because it is just no, it cannot be 2020.
You have said 14 days. That's why we are saying that not
Not
14
big to
days,
calculate, my lord.
213
Yes,
days.
my lord. 9th April
From which
2019.
Sarista this appeal is filed?
I have
Under your care. Why the valuation statement is not given in the
92. Yes, it is under the 92 of the Civil Procedure Code for framing of scheme
Say the incapable of
of valuation. It should have been
But has to be a valuation statement.
because it is arising out of procedure under
Absolutely.
section
So
92
you to say that incapable of
valuation.
like in a matrimonial.
It should have been. It should have been, my lord. It should have been. The framing of scheme under section 92 that was allowed against that, my lord. May I please? 200 এত জজ সাহেব বলছে অনেক দিন 2020 তো 2020 কে জানি কি করেছে কি ফেব্রুয়ারি 2020 ওটা বেনিফিট পাবো না ওটা বেনিফিট পাবো
Get the advantage of that Supreme Court judgment. I do not because it's constitutional staff report.
7/1/2020 তো পেয়েছি
90. So
অ্যাপ্লাই করেছে কবে দেখি
operating 490, 19 money. So
পেছনে নেই
we applied for certified copy when? Applied
7120.
17,690.
73, yes. And it was made over time of 7.
7,120.
May have a copies. I don't have the backside of this. It's
I believe that lockdown was. The appeal came to be filed.
সেটা আলাদা, ওটা পাবো না, ওটা পাবো না। 2020 দিন বলছে, 220 দিন। No, my lord, I am not entitled to get benefit of the COVID. It is prior to that, my lord. It is prior to that. It is prior to that.
What we are saying.
It is prior to that. Just before that, just file.
About a year before that.
Yes.
About a year before that.
No, it's March 2020 starts. Though it was filed just
27/2/2020. Date of- It was made ready on 7.
But the decrees of April 19.
19, my lord. This সই করেছে কবে?
He applied for certificate copy after 2 months. 3 months. 80 days period is there. And then from 7/1, another 1 month, he did it on 27/2/2020. So it cannot be 214 days. I have a,
I am entitled to get benefit of the
that the time taken for preparation
yes,
of the.
that will be excluded.
So what we have seen, it can't be because the judgment is dated. The judgment is
April
dated 9th
19.
April 2019. 19/6/2019 is May, June. So practically 2.5 months. 90 days is the period of limitation. So it was nearly 70 days after application. Then the limitation must stop. 7/1/2020 it was made ready for delivery. So the limitation would start from January 2020 again. And he filed it on 27/2/2020. So we take it how much? Not 214 days.
No,
Can't.
240.
Cannot be. It is not 14 days, no doubt about it. It's more. But 214 is not correct. Cannot be. Impossible. That's the wrong.
Yes.
Yes, that I have seen. That's the date.
That is
And then the requisite assessment was on 7/1. Requisite filed on 7/1. It was made ready on 7/1. So it can't.
Yes, I didn't go to
214 cannot be.
পেছন দিক দিয়ে দেখিনি বলে আমি
Why not 27?
It would be something around 50-60 days. Or
Like that.
something
Like that. Not 200. Cannot be. Steve, you know.
Yes.
Hey,
Can 2551. Which one is 2551?
can number
Can
2551 of 2020.
Application is for condoning the delay in filing the appeal. On considering the submissions advanced in support of the application, we find that considerable time was taken in preparation of the certified copy. The delay therefore, effective delay therefore, is nearly 2 months, which has been explained in the petition, in the application. We find the reasons stated out to constitute sufficient cause for condoning the delay in filing the appeal. The delay is condoned, can so and so allowed.
list another can on the next week. Means first week.
Yes.
Yes, call.
Item number 69, my lord, I appear on behalf of the petitioner, my lord. Well, my client being a challenged the order by which an application was like,
Other side.
the other side is
Mallet from 69, Mallet, I'm let Mr. Sharon strategy in this matter.
What is this application?
But-
First tell.
two applications, my lord, we have filed an application on the stay of the decree by which the learned trial judge had allowed the a decree for consummation of conjugal rights.
It's not an executable one.
Your lordship was pleased to pass an order staying the operation of the order.
No, We have simply said that not to create any kind
Yes.
of disturbances
Yeah.
at the residential house of the appellant for a period of.
Right.
That is what is the only.
And
way
in the meantime,
to-
my lord, your lordship was pleased to direct them to
Because your allegation was that she is coming
coming,
and.
yes. And my lord, we have filed an application and the appointment of handwriting expert, that is stand for, because you lordship know. In the trial court, my lord, we have said
Then,
that,
then he must get an opportunity
yes, yes,
to
that, my lord,
file opposition to that application.
yes, yes, what the initial application, but no affidavit has been filed till date. My lord, we have not received.
No, there was no such allegation that I am intruding into the house of the.
No allegation. We will record
But
that.
kindly takes the.
Nor, we will record that, nor you have any intention to go and create any kind of a ruckus in this house.
He said that he anticipates that this might.
No, my lord, in the application, we have
take up a
stated, my lord,
knife.
with the father being a influential person in the locality of a particular political party, with the help of people is trying to intrude into my house, saying that you have to consummate with the girl.
Nothing on record.
My lord, the girl, my lord, will also find that there are two allegations. My lord, the allegation is that he has, my client is saying that the marriage certificate bears the signature of the witnesses, my lord, which is unknown to the husband. My lord, the husband is staying in South Africa doing his PhD. And now, my lord, these persons are intruders and imposters, I do not know. My lord, therefore, my lord, we have filed an application in trial court when the data was not filed. Therefore, my lord, the handwriting expert will explain the entire
That
facts.
is a different issue. Once he says that there is no attempt on the part,
And
we will record that.
Yes, yes.
And there is no such allegation in the application itself.
Whatever we will
yeah,
record. Do you have, now tell us, do you have any intention to go and create any kind of a, the ruckus in his residence? No.
If it's-
No,
there
no,
was
I can
no
show you the
intent-
what.
Secondly, degree for conjugal rights,
It
restitution,
it's a paper dig. True.
nothing to do.
But
So, but
there is a
means but.
125 application.
Can
in
you
which
force
I have-
anybody to consummate? I have, sorry,
There can
hey,
be attached.
it's a matrimonial case.
And my lord, the only case that is which sought to be made out before your lordship.
Nobody can
Restoration, my lord, have served.
Have you served?
Yes. There is a delay of about 162 days. The reason being, my lord, the learned advocate.
You taken out an application for condonation
Yes,
as well?
yes, my lord. Can too. The learned advocate who had filed the appeal.
Steel Authority of India, which appeal?
My lord, it is appeal. It is an appeal filed from a judgment passed by the Railway Claims Tribunal. The railways had recovered some excess freight from us, so we had made a claim for recovering those amounts.
Right.
The learned advocate on record who had filed the appeal passed away during the COVID, and another advocate was engaged. He passed away in July 2023.
Those are the reasons for delay.
No, after his demise, the dismissal for default was in 12th May 2023. The learned advocate passed away in 17th July 2023. Thereafter, retrieving the records, I have pleaded all that in from paragraphs 15 to 20 of Can 2.
Can 2 is the application
Law.
for limitation.
Application for under section 5.
No. Can 2 is a for
Condonation of delay.
and can
1 is for restoration.
Can 2. Application for condoning the delay in preferring the application for restoration. The learned counsel referring to the averments made therein submits that in view of the unfortunate demise of the counsel, some time was taken for retrieving the file which has caused the delay in referring the application. Considering the said reason to constitute sufficient cause for condoning the delay as well as restoration, we allow the application for condonation of delay as well as the restoration application.
I'm good.
the appeal is restored to its original file now.
I'm good.
Yes. Hey, প্রথমে লিখে দাও that the affidavit of service filed today be kept on record. Despite the service, there is no appearance of the other.
That's it. I am for the petition.
What is
Lordship
this
directed to
application?
sign copy. The application for stay, but my lord, according to me, my lord, that he being the plaintiff, with that
Suit is dismissed. Suit is dismissed.
suit is dismissed.
No stay.
Now stay,
We expedite the hearing.
expedite the hearing, my lord, one thing, my lord, liberty to file fresh application, otherwise
What
the
application
defendant will
fresh?
transfer, respondent will transfer the property, sell out the property that is.
That is an injunction you have to take out then.
Yes, my lord, it is stay for the, justice can mold the prayer, my lord, that is
No,
also.
no. For the first time, no.
Status quo order, that is
No,
also,
no, sir. Supreme Court has recently said no.
Supreme Court, many judgments said it, it
No,
can be.
I tell you, the Supreme Court has made a very clarification in this regard. It says that the court can mold the relief provided by a passage of time when the appeal is or the proceeding is pending, certain events have taken place, certain changes has taken place, then the court can. But on the date when you moved, very first day, the court should not mold the relief. So that you can't do it. This is the first day you are moving it. That you can't. So in that event, you withdraw and file a application for injunction.
Yes, ma'am.
Say or whatever.
It is granted to withdraw the application
Liberty to file a fresh application.
view of the liberty sought for filing an application for injunction.
Yes, madam.
The can stands to suit.
Yes. Yes.
73. Two 73, my lord, we are for the appellant, we are praying for a not today, my lord.
Why not today?
Mr. Ashish Bagchi is appearing in this matter. My lord,
I
please,
appear for responding.
he has not come up for my lords today.
Very well, my lord, I'm ready to.
Not today.
Great.
What is the application? Can 1 and can 2?
Can 1 is for injunction and can 2 for recording of death.
So first thing is the can 2 is to be disposed of first. Who has died?
Respondent number 2.
Respondent number 2.
Yes.
There is no respondent here. In your cost title, there is only one respondent. Where you get the respondent number 2? In the memo,
Memo of appeal, my lord.
Pankaj Das Gupta
Yes.
died.
Died.
There is no heirs left.
Yes, my lord. Malay Das Gupta, son of late.
Oh, the son and the mother.
Yes.
Sorry, the father and a son. So son is already on record.
Paragraph 5, I have. Paragraph 5, my lord, I have mentioned.
The application has been filed.
This is can 2.
And to in view of demise of the defendant number 2 during pendency of the appeal, which occurred on 13/4/2021. The legal heir and representative of defendant number 2 is already on record, namely defendant number 1. The name of the defendant number 2 be deleted from the records. The defendant number 2 would pursue the matter. Defendant number 1 would pursue the matter. Application stands disposed of.
If you need service, the office is directed to make a appropriate amendment in the memorandum. What is this second application?
For injunction.
What is injunction? What is the suit for?
Suit for, my lord, there is a suit for partition.
Dismiss?
No, degree.
Preliminary form?
Plenary form. This is the, my lord, the refugee rehabilitation scheme.
If you can transfer your share, then why they can't transfer the?
No, I'm not. Some of the transfer, my lord, I'm not. The the leave of the court, my lord. I know. Not the no final steps for taking.
How can it? Preliminary degree. How can you be evicted on the basis of the preliminary degree?
No, my lord, the suit was dismissed. Beg to be corrected, my lord. Suit was dismissed.
Interfere. That is interfere with and
Position.
So where is the finding that you are in position?
Yes, if your lordship highly considers.
The judgment of the trial court show us. Show us that your position is found.
If your lordship may I turn to internal page 7.
Which portion?
Page 7, if your lordship may
To prove this test, the plaintiff only produce LR record of rights to information slips and Panchayat tax receipts,
Yes.
which is in the favor of the plaintiffs.
Yes.
So, my lord, these are privacy documents for the only for possession. I'm not on title also. Concerning documentary evidence from the side of this court opines, these documents are not sufficient to hold. Patta was issued first in favor of their mother and thereafter reallocated in the name of their father as Exhibit 1. Is not a finally published LR record of rights. Exhibit 2 is not a certified copy of the LR information slip. There is a computerized LR information slip where whole information does not reveal to bring the clear picture. Though Patta issued in favor of the mother of the parties to the suit is the admitted fact by the defendant, but only admission does not exclusively confer such weight and sufficient to hold. The Patta was issued in favor of the mother to the parties to the suit and thereafter reallocated in the name of their father on death of their mother as penciled by the plaintiffs in their pleadings.
What was the stand of the defendant?
It was allotted to the defendant.
Patta.
It is under the refugee rehabilitation scheme, my lord.
That was your case is that it was initially allotted to
Mother.
mother. After her death, it was in favor of the father.
Father and father to the son.
Father has gifted to the son.
Son.
Defendant.
Defendant. He is claiming exclusive title over the property in question. And pursuant to which
What
the
about,
new
what
Patta
about
has been
position? What about position?
position, my lord. No discussion about this, only to that aspect.
Then in that event, it is very difficult because you know Kishore Khetan's judgment of the Supreme Court.
Yes, let us go without finding any.
No, because
I have not
we have to
invented
then
a law.
say, we have to say that you are in position, and then disturbances cannot be created.
Apart from that, my lord, there is
Where you can show that either the defendant has admitted or there is any kind of a thing that comes.
On the contrary, Exhibit A is also on record.
that it is
Issued in favor of the defendant.
yes, because after that transfer, my lord, the new Patta is issued in favor
True,
of the
that is
defendant.
what I'm saying, that even thereafter you continued in possession and all, everything is
Apart from
there.
that, my lord, there is nothing on record to substantiate, my lord, so
Then
the position.
you serve and come back. Then we can't pass an order in this.
Only so for the transfer portion, my lord, Kaliko.
Transfer, we have a different notion.
So for the admitted share, he can transfer.
See, it will be a list pendants, service returnable after 2 weeks. The appellant is directed to serve the copy of this application upon the respondent by speed post and shall file the affidavit of service on the returnable date. The application is made returnable 2 weeks in. Rakha uchit.
The initial application I have served, my lord, now. We'll see.
Next.
In this matter, 276 to 281, my lord, I am appearing, my lord. So, my lord, I am not well.
You are for whom?
I am for the petitioner. Section 5 application.
Come on the petitioner side. I thought that you are for the respondent.
No, I'm sorry, my lord. My lord, I have some breathing problem last few days. I could not come in time also in court. And that is why I'm praying only not today, because my senior was also admitted.
Hold your breath. Don't.
My senior also.
Hold your breath. Yes. Not today. Not today.
My lord, I'm praying 10 days time. Only.
It will be a 10 days time because the next week is all holiday.
But in the meantime, my lord, I have.
Go. Come on that week. Yes. Not today will take us 10 days. Don't worry.
276 to
281.
I'm good.
I have 285, my lord, I am for the.
What are these three applications, sir?
My lord, three application for condonation of delay. One application for.
Have you served?
Well, I could not serve.
Serve.
My lord, this is the matrimonial suit. Now, two applications has been filed.
Serve the copy and come back. Condonation is there.
Yes.
So you serve. We are giving you a short notice, 2 weeks.
My lord, in the meantime, if the husband
We can't-
contacted the second marriage,
We
then
we can't
but
pass.
while I am in, we living with him, I am living with him, giving the wrong address. He filed the suit where he resides. After, my lord, 3 or 4 months where I have been driven out from there and came to learn that the S40 degree of divorce has been filed. My lord, I know.
এটা ওনাকে পড়াও।
My lord,
Please read. Tell us whether we can. Sub rule 3.
my lord. Where an application? My
So it's better. That's why we're giving you a short time. Short notice, 2 weeks.
my lord.
2 weeks.
All 3 applications I shall start now.
Yes, please, sir.
My lord.
Next.
Num.
And during this Fagun Mass, nobody will marry.
No.
Yes.
I am for the 27, my lord. I am for the respondent, my lord.
What is this defect? Why? This you are the appellant.
I am for the respondent.
Then why you change your side?
Sorry.
What is the defect, madam? Have you seen that?
No, my lord, but I have already paid
What
it.
are you doing? 20 rupees can't you pay?
My lord already paid
Show
it.
us that you have paid. Yes. There is a filing number. There is a filing number, madam. Madam, something is to
My
be
lord,
done.
clerk had filed it, but
But then he's not a good one because he has to note that what is the filing number.
my lord, I will remove it. My lord, keep it.
Remove it means? Sorry? What is this application, madam?
Application.
What is this? No,
appeal, my lord.
application. You have filed scan 1.
Can one for stay?
What is stay, madam?
Stay of decree, my lord.
What is the nature of the decree? It is against a preliminary decree or final decree?
Yes, my lord. It is against final decree.
Final decree. Execution proceeding has been levied?
No, my lord. Execution proceeding.
Execution has not been. Have you put the decree in execution? I am asked, sir. She is challenging a final decree. Have you put the final decree in execution? No, that deposit will not do. The execution has to be levied. Whatever, then we have to stay the execution proceeding. Otherwise, first appeal is a matter of right. Matter of right. So we have to stay. Otherwise, if it goes on, then what would remain in the appeal? Nothing. Yes. The work of?
Surveyor is not valid. Stop.
No, that is in case of a preliminary decree, sir. Had it been against a preliminary decree, what you say is that the partition commission work will continue, no difficulty, but final decree should not be passed. Now, this is against a final decree. then in that event, this has to be stayed. Otherwise, then what would remain if the final decree is executed, property is separated? It is, then there would remain nothing in the appeal. At least I am happy that the final decree has been drawn up here.
No right over him.
Which one?
It is.
The order, then it should tell the second is the defendant of C.
No. It is against the preliminary decree or final decree, madam?
Preliminary decree, my lord.
So,
Preliminary decree. Learned trial court cancel my deed of gift.
that I have seen. It's against the preliminary. So you have no share in the property.
During the lifetime of my grandmother, she executed a deed of gift in favor of me.
Who are you?
I am defendant therein.
Madam,
But I have share in this property, my lord, by virtue of this gift, deed gift.
now deed of gift has gone, has been declared as void. I was just trying to understand that the court has held that the plaintiffs have 2/3 share in respect of A schedule property, and the defendant number 1 has 1/3 share.
Yes, my lord.
So other defendant means 2 to 4, they do not have any right. Then so far as B schedule property, it held that the plaintiffs have 4/5 share, and then the defendant has 1/5 share. So you do not have a share.
My lord, trial court urged that cancel of this deed, my lord.
What has been held? The property originally belonged to your mother, the donor.
But she inherited from his husband, my lord. From his husband, he inherited. He inherited it.
Yes.
After then, she gifted
share.
me. Her share she gifted me.
No, that is true.
I have registered deed of gift, my lord. I am one of the co-sharer of this property, my lord. But after execution of
his father was a co-sharer. Father
Yes,
is
my-
alive.
father is alive, but my lord,
Then what?
but my lord, his grandmother, her share gifted him. By
Madam, the difficulty is that
undivided share, my lord, undivided share of this property.
the grandmother was a class 1 heir or the whatever was a class 1 heir. After the death of the grandfather, your grandfather, it devolved upon the grandmother and your father and the uncles or the aunts. I do not know.
Yes, my lord.
You do not come under class 1 heir. Now they all have the equal share upon the death.
Yes.
Now you say that the grandmother executed a deed of gift in respect of her share which she inherited.
Yes, my lord.
Now this deed has been declared void.
In this suit, my lord.
Correct. So declared in this suit is should be in this suit itself. Has to be. There is no other way. So this declared void. That means if her divestition goes, then her undivided share will devolve upon her sons and the daughters, which is what has been done.
Yes, my
You as a grandchild does not come because your father is also alive. He has got that share from your grandmother. So this is what has been held now. Your grievance is that your deed should not be declared void.
Yes, my lord.
In such scenario, what stay? What stay? What we will stay? Tell us.
My lord, execution, they have done.
They can't because it is a preliminary degree. There is no question of any execution. It is not executable. It's mere a declaration. Declaration of shares and a declaration that the deed is void. Something else is to be pleaded. Something else to be. What is that something?
If share will divided, my lord, if share will divide. My lord, if share will divide and it attain finality, then what about my share, my lord? Then
Think about it. Whether you will pursue with this application. If you pursue, then we will make our observation whether this order can be granted at this stage or not. Or think about.
তাড়াতাড়ি করার জন্য এটা
permission.
What to do, madam? Choice is yours.
My lord, allow me some time, my lord.
Not today. Take back and ascertain from your clerk whether what is the filing number. Let's call the next.
The wife is the appellant in suit granted decree for divorce. Section 5 application is there, my lord.
Yes.
wife is before your lordship against the degree grant for divorce.
Oh.
Section 5 application is there, so there is direction for service. I have also filed an application for alimony. So both the application, my lord.
2 weeks. In anticipation, we will not pass.
Period.
Let's call the next.
Lordship, led by Advocate Kiran Sheikh, who was representing on behalf of.
I am not led by anybody. You said lordship led by, so that's why I said no.
He is suffering from fever. Lordship, please kindly fix immediate.
Not today. Why? Second appeal? देखी तो. Restoration. 299. 299 তো কল করেছো?
No, 289.
289.
289.
Okay.
280.
No.
My lord, I am the appellant, my lord. I am the mother, my lord. So against my lord, ex parte order, my lord, pass in favor of the my guardians and wards act. Now there is a delay of 762 days.
Service.
My lord, not my lord. My lord,
Service.
execution is already filed, my lord.
2 weeks.
2 weeks, my lord.
Yes.
Mr. Partha Chakravarti appeared for the appellant applicant. Madam, I would prefer not to demand it.
Next.
Advocate Juidatta Chakravarti for the appellant. I am praying for not today, my lord.
Yes, next.
Grateful.
I appear to the appellant. Lord. Last occasion, my lord asked me to serve. That I have served. But the persons have. Mr. Rai is appearing on behalf of one of the respondents. Actually, not the Shilad.
Who is appearing?
Mr. Parthaputim Rai.
He was here.
He was there, but I had told him. He is appearing on behalf of the one of the respondents. And another is Mr. Sukumar Bhattacharya. Number two, so last occasion they paid for time on 20. Fixed it on no. One of the respondent number 1.
He's supporting you.
Yes, supporting. This case is common. Last occasion.
Injunction from changing the nature.
Allowed. Order 39 rule for allowed. Okay.
Allowed.
On the ground, blood, no ground made out.
Can we
dealt with order 30
let us see? Can we fix this matter on 27th? We will dispose of the main appeal.
Yes.
Let this application be listed along with the appeal on 27th of March 2021, 2024, under the heading for orders. Which one?
36. Only direction for service, nothing more. Section
Alright.
5 application and stay.
Service.
2 weeks, 2 weeks, my lord. 3 weeks.
3 weeks.
336, section 5 and stay. And get to your lordship.
Yes, we have another bench at 1.
Yes.
But item number 4, I am here.
Yes, call the list.
My lord, item number 1, I am appearing for the respondent.
I am appearing for the petitioner, my lord.
What is this application, madam?
My lord, here I have prayed for modification of the order dated 26 September 2023 passed by the Supreme Court. Here, the award, arbitral award was in my favor. Thereafter, section 34 was filed by the other side before the district judge, which is also rejected, dismissed, and thereafter again he challenged under section 37, which was also dismissed by this honorable court. But in the meantime, the stay has been obtained by the other side, and in the stay application,
What is stay?
My lord, now the status is that we have filed an SLP before the Honorable Supreme Court.
Yes.
And it has been refiled and it will be taken up after a holy vacation for hearing, my lord.
my lord, this is a false submission.
So, not false
submission,
submission, I
because
can
in
file
their
this.
opposition, no such SLP I am seeing. Only the diary number they have provided, and also that has not
My
been.
lord, I have received the acknowledgement from the advocate on record from the Supreme Court. I will file, my lord, along with the affidavit.
Because the document I am seeing is that it is showing defective matters not refiled after 90 days.
It has
Diary number is also not provided, not registered also. And my lord, it is
Yesterday I
6
received,
months,
my lord, I will
6
bring
months.
bring it on
Status
record.
quo is there. No status quo is there, my lord. I have filed this application modification of the order because already they have deposited. My lord, kindly I may be permitted because they have deposited an amount of 7 crore 50 lakh as per this order of this honorable court before the registrar through a check bearing number I have mentioned in my prayer 097167 dated 28/4/2023. That amount, I want that amount to be released in my favor.
This
Also
is
that,
not a modification. This is not a modification.
my lord, in the order also, judgment also, that has been not been mentioned, my lord. That I want that my lord, that amount may be mentioned, that they have filed that amount before this through this registrar.
Modification of the judgment and order dated 26/9/2023. Full stop. It is submitted by the counsel for the respondent that they have approached the Supreme Court with the special petition, and the same is likely to be listed after the ensuing holy vacation. So in such view of the matter, we deem it fit that the matter may be posted for hearing in the second week of the month of April 2024.
My lord, the petitioner is
Come back.
suffering, my lord. 6 months it is. And
Yes.
3 years I have done my work, but not.
We will now, if you want, then we can reject your application on one single
My
count.
lord, my lord. I will come.
This is what we do not want. Let us see the fate of that.
My lord. I will
Oblige, my lord.
oblige, my lord.
Oblige, my lord.
Yes, next.
My lord, item number 2, my lords, the order has been complied with. My lord, the affidavit of compliance, does my lord have the affidavit of compliance? Otherwise, a photocopy my learned colleague is carrying.
My lord. Give it.
My lords, the direction my lord had passed to reconsider the case of the petitioners. And my lord, in terms of that, my lord, an order has been passed.
Appearing for the petitioner.
Petitioner, my lord, yes, he's here.
My lord, I am appearing for the petition, my lord.
Now he says that the order has been complied with.
It has
Whether
not been taken. The order has been- I have not received. No, of course.
So, 15 December 2023 order.
so it has been done within 6 months, 6 weeks.
No, as per the direction, past direction, compliance has not been done.
No, if he's aggrieved by the order that is passed, it's fresh cause of action. He has to file a fresh proceeding.
That is what we wanted. What we have directed is
Yes. My lord, definitely, my lord, there has been a delay, my lord. So we are apologizing for that.
fresh. the authority is directed to reconsider the case of the petitioner afresh. That has been done,
Yes, my lord.
which where
This is the order, 15 December 2023, my lord. Page 17 of the affidavit of compliance. Affidavit of compliance, page 17. My lord had directed us to reconsider. There was no mandatory direction, my lord. So we have.
no, that's the mandatory direction. What more?
Yes, my lord. We have done that, my lord. We have reconsidered and passed an order, my lord.
Anyhow, they have already decided it. Now, if you have a remedy, you can pursue your remedy. This is a fresh cause of action. This is an application for contempt alleging the willful and deliberate violation of the directions passed in the judgment and order dated 25/9/2023. By the said order, this court directed the authority to reconsider the case of the petitioner afresh in the light of the observations made therein, and the entire exercise to be completed within 6 weeks from the date of the communication of this order. So the affidavit of compliance filed today reveals that the authority have passed an order, being order number 2549, dated 15 December 2023, disposing of the proceeding. So stop. Though we find there is a delay in completing this exercise as indicated in the said judgment and order dated 25/9/2023, but we find that the moment a decision has taken place, we do not think that there is any justification in pursuing with the contempt petition. So, if the petitioner, the petitioner of the instant contempt application is still feeling aggrieved by the said order number 2549, it is open to the petitioner to challenge the same before the appropriate forum, as it gives a fresh cause of action. In such view of the matter, the contempt application is dismissed. Next.
My lords, in the next matter, my lords, a special leave petition has been preferred. An interim order is passed by Supreme Court, my lords. My colleague is in court. He'll just hand over the order.
No. No, this contempt application arises from
the same order, my lord, 29 September 2023 order.
The contempt application is taken out alleging the willful and deliberate violation of the order, a judgment and order dated 29 September 2023. So it is submitted by the counsel appearing for the alleged contemptor that the apex court has directed the issuance of the notice upon the respondents therein, and also state the operation of the impugned order. So in such view of the matter, let the contempt application be adjourned sine die. Liberty is granted to the respective counsels to pray for listing of the instant matter in the event the occasions so arise. Next.
Yes, my lords, in the third matter, my lords, special leave petition has been filed, my lords. I am praying that my lords may have it after some time, my lords, so that we can.
Appearing.
Item number 4.
My lord.
SLP.
My lord, kindly see, my lord, my clients already retired. Out of 10, my lord, 3 persons already retired.
My lord, we'll take expeditious steps, my lord, we'll get the
Will
SLP.
not take any expeditious disposal, my lord. Already 6 months
My lord,
passed.
pending specially petition, my lord,
They
and pray for it.
No, don't say. Then you'll have to, we will rely upon Order 17, Rule 2 of the Supreme Court rules.
My lord. I'm only humbly praying, my lord, for an adjournment.
Please go and read that.
My
It's
lord.
that mere filing a special petition does not mean that the operation of the order should
No,
remain.
no, I'm not suggesting, my lord. I completely bow down to that. I'm only humbly requesting that if my lords may have it after some time, so we can.
When it is supposed to be listed.
My lord, there is no date of listing, but we'll expedite it. My lords may have it after 4 weeks or so, my lord. We'll.
Still, it is still at the diary number. There must be
Because
Yes.
there is because it is filed with condonation. That is why it's diary number. That it is not because that there are defects, my lords. But we'll take steps, my lord. We'll take steps.
See what
I
it
may be permitted to submit only few things.
Yes.
Out of 10 applicants, my lord, 3 already retired. They are not paying the gratuity and leave encashment also.
No, no, no. It's for financial benefit. They'll get it, my lords. Retirement doesn't matter, my lords.
To the scale. Leave encashment, why they will
4
not
weeks, my lords. Grant me 4 weeks, my lords. I will instruct the department if they are not able to get a.
My lord, I am praying for issuance of rule, my lord, upon the letter.
No, no, my.
The direction which was passed.
My lord, kindly come to page 23.
What we directed.
My lord, page 23.
Yes.
However, we appreciate that the submission of the learned advocate for the respondent that because of the pendency of the instant writ petition, the time fixed therein has elapsed, and it would be undue hardship to the administration if such time is not extended by the consequences for such non-implementation of the said order. That's a
And this order is assailed before the Supreme Court.
Yes, yes, my
my lord.
Yes.
It was assailed in Supreme Court. No, number was given. Already 6 months lapsed.
No, my lord may grant us 4 weeks, my lords. We'll take steps, my lords, and we'll inform the status, my lords.
Not 4 steps. No 4 weeks. We are just granting them because next week is a holiday. We are just providing them one more week. That is the first week of April. We are fixing this matter in the second week of April. Don't worry, we'll take care of that. If you have waited for such a long time, wait for that.
Only one submission. Yes. They should release the gratuity and leave encashment. My lord.
It is.
My lord, kindly appreciate, my lord.
Second week.
My lord, the dispute is with regard to the pay scale, my lord.
The contempt application is taken out, alleging the willful and deliberate violation of the judgment and order dated
22nd September.
22nd September 2023. To stop. It is the alleged contemner is represented. So it is informed to us that they have filed the special petition before the Supreme Court.
Defective.
Which is likely to be listed in a due time. Though we are not convinced that the matter should wait as one of the party has filed a special petition.
Not party,
for the
administration filed the
he was a party to the proceedings.
Yes, yes.
For the simple reason that we are filing a special petition does not tantamount to stay of the operation of the order unless expressly granted by the Supreme Court. Be that as it may, we feel that an opportunity should be given so that the steps may be taken before the Supreme Court to get this special petition listed, and therefore direct this matter to be listed in the second week of the month of April 2024. So, in the meantime, there is no fetter on the part of the administration to release the admitted
gratuity
entitlement in favor of the persons who under the law is entitled to get
that
this.
may be clarified, manner. Gratuity and leave encashment.
I say the statutory entitlement, whatever you are entitled.
Because matter is related to pay scale, my lord.
I understand. Only thing is admitted, because they have admitted a particular scale of pay.
With
You
regard
said,
to pay last case, there is a dispute.
please, they admitted a particular scale of pay. You claim that no, this can't be. There should be a
Better pay scale.
better scale of pay.
Yes.
Both the courts, means the tribunal as well as the High Court, has granted that it
yes.
should be. So original scale of pay is admitted by them. So on that basis, if they want to pay, let them pay, and thereafter the differential will come.
My anxiety is that, my lord,
They will. That's why we said.
3 persons retired.
That's why we said that they admitted they must pay.
At least
Where is the difficulty?
the retire is entitled to get, my lord. That may be,
They say.
my lord, that may be. Otherwise, my lord,
We have said, please read that line.
for getting the retail benefits, they are
We
staying.
have said, please read the last line. What we have said. We have said so in the meantime. What we have said.
Gratuity and
Just
that may
read
be.
loudly. Read loudly. In the meantime, follow. अरे last sentence টা বলেছি যেটা
For this case, my lord, I came from Port Blair.
just listen. No, thereafter.
Last 2 lines.
We do not want to restrict DA and the other leave encashment. You do not know. There may be some other admitted dues. Please do not. That's why I say whatever the statutory entitlement, they will disburse.
Within time frame, my lord.
Let them
My
do
lord,
it.
please, my lord. Kindly, my lord. My lord, my client.
Within 3 weeks.
Ah.
He has traveled so much, so 3 weeks.
But my lord's first part, my lords has not changed. My lords had said there is no fetter.
No.
Very well, my lord.
I'm deeply obliged, my lord. My lord,
Yes.
sometimes
Next.
my name is.
Yes. Yes.
My lord, the next matter, my lords, we have complied, my lords. Affidavit of compliance is there, my lords. I think.
The next matter.
My senior, Mr. Binu Kumar, is appearing for the petitioner in this matter.
He has complied the order.
My lord, the order has been complied with.
Yes. Both the councils appearing for the respective parties submits that the order has been complied with, and therefore the application for contempt should be dropped. In such view of the matter, the contempt petition is dropped.
Most grateful, my lord.
The affidavit of compliance filed today be kept on record. Yes.
May it please, Your Lordship. But this is my application, my lord, for recalling of my lord's order. My lord, yes. Yes. My lord, here, my lord, the premise of my lord's order, my lord's rejection of my prayer for compassionate appointment, my lord, was that my father was never a permanent employee. My father was a works charged employee, not a permanent employee. So on that premise, my lord, lordship has rejected my case. So, my lord, my only ground for recalling is that the service group of my father, and also, my lord, my I just beseech your lordship, my lord.
No, sir. There are judgments. If you say that there is a distinction between a review and the recalling and or modification or rectification.
But
if you do not come within that purview, then sorry, we can't do it.
I just beseech your lordship will only, my lord, just.
Then I can give you a judgments of the Supreme Courts which says no.
But
Jayaprakash University's judgment, right from there, you just read it. It says that it cannot be done.
Very well, my lord. May I just read out, my lord, Jayaprakash and come back to your lordships?
You read it, find out. If you want, I can give you the.
My lord, I'll just find it
from there. I will give you 6-7 judgments.
My lord, only, my lord, just it has been a prayer.
No, it can't be done.
My lord, I just beseech, my lord, it is my at least my learned senior, my lord, ought to have, my lord, placed before your lordship the actual facts.
Anyhow, whatever. This can't be done.
And also, my lord, the mother.
Not today.
As your lord,
can't be done. Read.
Grateful, man. Gratefully. Gratefully. It is Jayaprakash Reddy's, man.
Jayaprakash University's
I'm so sorry.
But I beg to appear on behalf of the petitioner, applicant in review application.
Why you use this expression beg to appear? You have a statutory right to appear and represent your client. Then why these colonial expressions are used? Why? What is the ground for review?
Lord, Lord, I have already served upon the concerned respondents. The ground of review is your lordship kindly have a look through.
I do not know. Yes. What is this?
Lord, your lordship will find, kindly see the memorandum of review. Is vitiated due to error, ground number 1. Apparent on the face of the record when it appears from the judgment itself that Director of Personnel and ex-officio Chief Engineer, Irrigation and Water Directorate, Government of West Bengal was of the opinion that the petition is found eligible for appointment in Group D post, and the Honorable West Bengal State Administrative Tribunal also directed the competent authorities of the said department to absorb the writ petitioner applicant in Group D post, and even in the order under challenge passed by the Honorable Tribunal, it was held that the petition applicant is not entitled to absorb in Group C post, but he is only to be considered in Group D post. But while deciding the writ petition, finally the Honorable Division Bench failed to consider such aspects of the matter, and without any observation to that effect, and whether the service period of the petitioner for 32 years would be considered as an employee under Group D post or not.
That is, you wanted us to revisit the judgment.
No, your lordship kindly consider.
Is it an error apparent on the face of the record? Tell us.
That's not. That is not.
Tell us.
But it is evident on your record that that was the order.
Which portion? Please tell us. Show us that which portion of the judgment
I am telling you,
is contrary to the record, and there is an apparent error on the record.
My lord,
we are open to review. No difficulty. Tell us.
My lord, kindly take up my application.
I am looking at the judgment which you sought to review. Which portion you really wanted to say, and then tell us from the record that it is absolutely error apparent on the face of the record.
My lord, your lordship.
Show us.
My lord, regarding the judgment, I have nothing to say, my lord. I have nothing to submit before your lordship. Regarding the judgment, On the point of res judicata, I have nothing to say. My lord, what have been held by your lordship, I am agreeable to that.
Copy down ওখানে ওটাই রিভিউ, এটাই তো রিভিউ, এটাই বলছি। This is the judge. Yes.
My lord, your lordship, kindly have a look to the conclusion.
Conclusion.
Page below 20 of my lord, memorandum of review.
Yes.
Your lordship, conclusion. In the present case, the right of the petitioner relating to his prayer and cause of action against the same authority attained finality as admittedly no writ petition was preferred against the order in way number passed on in 2017 way 1103 of 2011. Thus, in view of this said order, the tribunal rightly held way number 864.
Now tell me why it will not be barred by res judicata. The bench has held that because of these orders, where the issues remain the same, why not? It will operate as a res judicata.
Yes, yes, I am agreeable to that. That is all.
Then where is the difficulty?
Why I am coming? I am coming. Not only the res judicata point was there, other also was there. That is
What
why
others?
I am inviting your lordship kind attention to the application where the impugned order under this writ petition is to be looked into, your lordship. There are another.
Madam, I tell you, my own judgment is staring at your face. I have already held.
One part of the judgment.
I have held that if there is a roving inquiry which is to be made by a court to find out the error, then in that event it will not be regarded as an error for the purpose of review. If we have to assimilate all the facts again and then to find out the error, this is also not a ground for the. It should be a patent error on a mere look that we have held that the particular thing is correct. From the record, you just show us that no, it is not correct. That is an error apparent on the face of the record. We are ready to accept. Do one thing unnecessarily. You prepare yourself. Please go through the judgments of the apex court on the review scope of review. Go through it. Now you have an opportunity to file your opposition. File your oppositions. Affidavits. How soon? 2 weeks. 3 weeks. One week. 1 week. 4 weeks. File. Let's call the next.
Lord, may I file the affidavit of service?
File it.
To it align.
ये दाओ. Eta now. Call 3.
3 minute
Contempt.
Contempt.
Look at the plight of the bench. Either patent error on the face of the record review, and secondly, not complied with contempt.
That is for reason your lordships are not the regular bench.
Look at it. Look at the facial expression of Mr.
Whatever
Mukherjee.
the expression of Mr. Lord Mukherjee,
Mukherjee.
but that has to be looked into. What report has been submitted, I have to take instruction.
What is the nature of the order? Tell us. Where that, which page 45 of the contempt? Not page 45 is the order of the another bench. So why it is coming before us?
No, that bench is not available. Your lordship was assigned that determination.
It is assigned matter.
No, at that time.
Lordship.
Regular
Chief
bench.
Justice has lordship assigned the before his lordship.
This contempt application was assigned.
This honorable bench.
This honorable bench, Chief Justice assigned. Honorable Chief Justice.
After retirement of honorable justices, both thereafter it was assigned to.
No, we may have a regular determination. That is a one thing. Whether
let it be before your lordship.
what is which group matter?
This is group 2. Group 2.
So at that point of time, we had a group 2 determination.
Yes.
But now we do not have. Our order is not under challenge.
That's
How can we take up the matter?
Lordship, no jurisdiction.
Lord, as your lordship dealt with that, Lord,
No.
initially that is why, Lord.
Sorry. The contempt application was, the contempt application is filed alleging the willful and deliberate violation of an order. This is of 2015 order. 1712. Contempt
1712, Lord.
of the order dated 17 December 2015, passed by the division bench, comprising of Girish Chandra Gupta and Asa Arora JJ. Stop. The contempt application was entertained as this bench had a determination at the relevant point of time. Stop. The matter has again listed before us as if the matter has been assigned to this bench. Since we do not have the determination to deal with group 2 matters, let this contempt application be delisted from our bench.
Lord, your lordship, your lordship, kindly,
The
Lord, I am
affidavit
filing the affidavit in reply to the opposition filed by 3 respondents. Lord, let it be kept with the record, Lord.
Yes, affidavit in opposition and the reply, affidavits in opposition and the affidavits in reply filed by the parties be taken out. Next, for
Lordship, let the Lord's copy has been served upon me.
Copy down again.
yes,
For, I am for the petition. Contempt matter, my lord.
which order
Lord,
dated
order
24/6?
24/6, yes.
24/6.
24/6. Page number 39 is the relevant portion. Page number 39 is the
Page?
Page number 39 is the relevant portion.
Oh, this is again listed here, 39. What is that? Accordingly, BLLRO Kejuru is directed to correct the erroneous record of rights and remove the record of wasting from LR in respect of 1/3 share as per the status declared in respect of the co-sharer. So that has been done.
No,
Lord,
nothing has been done.
Why you have not done it? Why you have not corrected the record?
But against my lord's order, my lord, SLP preferred, SLP dismissed.
So,
and my lord, I am praying for some time for compliance, my lord's order.
we don't know.
My lord, only one thing,
D'accord.
kindly consider
This
for
stuff.
annulment. My lord, the annulment.
Sorry, we cannot go into this. We will go by this.
My lord, for this, my lord, I am
Sorry.
praying for time, my lord.
We are granting your time.
My lord, granting time for compliance. My lord, that is.
We are granting time. The contempt application is taken out, alleging the willful and deliberate violation of the directions passed in a judgment dated 24/6/2022 by the said judgment BLLRO Kejuri Roman capital 1 was directed to correct the erroneous record of right and remove the record of wasting from the LR ROR in respect of 1/3 share of the writ petitioners in WPLRT 10 of 2022 and WPLRT 11 of 2022 as per the status declared in respect of one of the co-sharers, Chitis Chandra Kamila in WPLRT 545 of 2001 in respect of the land in question. It is informed by the LS contemner that the said judgment was assailed before the Supreme Court in a special petition, which is dismissed on
16 January 2024.
16 January 2024. 2024.
24.
24. Stop. However, the LS contender prays for extension of time so that the compliance can be secured. Stop. In such view of the matter, the contempt application is adjourned for a period of 4 weeks from date. In the meantime, it is open to the LS contender to take an appropriate steps in terms of the said direction.
So one thing, since the election is going on, the SDO is the authority for annulment of PATA.
I do not want to say anything on that. You have to do it. This is your quasi-judicial authority. You are a quasi-judicial authority. It does not remain suspended. Sorry.
In respect to that case of 2001, for 24 hours given, the authority came
anyhow,
and done the matter.
We know. 4 weeks, 5.
5 weeks of same way, that's 11 and that is 10.
Same order.
One thing, kindly record that SLP. Kindly record that SLP
Not
number.
necessary. 6. 5 the same
5
order.
হয়ে গেল তো, একই হয়ে গেল।
6.
Much obliged, my lord.
Item number 6.
I am for the,
Contemner.
no, madam, for
Petitioner.
the petitioner, my lord. First time it
Have
is
you
same.
first time appearing? Service. Returnable after 3 weeks. Application is দরকার নেই? Yes. Single bench.
Single bench, my lord.
Give the number. Yes. Yes. 1. What is this?
That, in summary, my lord, there is, my lord, a factory. Let me not go into issues of fact which are not relevant for a contempt petition. The way, my lord, I see it is, there is an order. I'm supposed to, my lord, act in terms of the order. Now, my lord, if your lordship is pleased to see the order and the acts of contempt.
Now, can you do one thing? Can you do one thing? Both of you, can you file a written notes of argument?
Yes.
Please file it. So I want to minimize it because the single bench sitting is a very difficult one.
Yes.
Because of the various.
No, that's right.
So if you can do it, then if you want to say something on that, we will hear you. I will hear you.
We can file our notes, and if your lordship wants a clarification, then
anything, then I will definitely.
Very well.
You file it.
Very well.
This matter was substantially heard, and and therefore I feel that the parties must file their written notes of argument. Let both the parties file their written notes of argument within 2 weeks.
Yes.
1 week is a holiday. You spend time for that.
Yes, ma'am, within 2 weeks.
No, 2.5 weeks.
2 weeks.
Whatever I draft, my senior discards, even after 23 years. But he will insist that I should draft it first.
Who?
Mr. Mitro. Straight dustbin. Recently, a statement of claim, my lord, he has retained more than half.
Then I was fortunate.
Your lordship is talking about senior Mr.
and-
Mitro, my lord.
Sorry.
I am a junior Mr. Mitro, my lord. What can I do? Recently, one statement of claim, my lord, he is retained. Only pen correction. Rest dustbin.
He has retained.
Yes, with only pen correction.
I'm becoming lazy.
Otherwise, total discard.
Mostly.
Thank you, thank you.
Okay, say 2 weeks and notes file got the bulletin.
Okay. Any lecture, I'm here. Then Mr. Shah travels a lot quickly. Whichever day, man, I'm. Lordship, keep it week starting 15th, whichever day. Yes, so, apart from 18th, like kindly keep it in. 16, 17, 19. 19, Lordship, 19. 19 Fridays. 19. Notes, right? Oh, concerning